All right. Good day, everyone. Welcome to the third installment in our three-part Hotspots webinar series. This one is on evolving issues in workplace investigations. Workplace investigations certainly made the cut when we were identifying what are some of the key issues, the challenges that organizations are facing as we try to stabilize, recourse, and recalibrate as a result of the impacts that we've all sustained as a result of the pandemic and all of the other issues that we've endured. Investigations, we can tell you as investigators, have spiked considerably given our current climate, and what we intend to deliver in this hour session is we're going to provide you with really a bit of a roadmap, a heat map, if you will, in keeping with hotspots. What are some of the key issues, key considerations, best practices, and critical strategies that you need to keep in sharp focus to ensure that your workplace investigations that you may conduct internally, that they can withstand scrutiny and challenge, which often they do, particularly because the output of investigations also often results in individuals, at least one, or maybe several, not being satisfied with the outcome. So just by way of introduction, for those of you who aren't familiar with our firm, or myself and Aleksandra Pressey, who's my co-facilitator today, I'm Maura Williams, Managing Partner of Williams HR Law LLP, and also CEO of Williams HR Consulting Inc. I know you can see me on Zoom, but we always show you a picture because I want you to know what I look like before the pandemic. And this is my co-facilitator, Aleksandra Pressey. I also show you Alex's picture because this is what she used to look like before the pandemic. She now is blonde. So with that, let's dive into what we have set out as our session roadmap, the content that we're going to cover in today's session. So what we have set out as our mission to accomplish in this time, should you choose to accept it, is we're going to explore the following. First of all, fundamentally and foundationally, what makes workplace investigations challenging? So there are common challenges that have always existed, as workplace investigations inherently are complex. So we'll look at some of the common pitfalls and some of the realities as to what makes in workplace investigations challenging just generally, but then we're going to train our lens on what makes workplace investigations even more complex when we consider the overlay of the current climate and the complexities of the times that we're in right now in the new world of work, or I like to refer to it as the new workplace. Then we're going to shift gears and we're going to look at, we've got almost like a hotspots within a hotspots segment here, because we're going to look at the hotspots, some of the key challenges that organizations typically face when investigating. And we're going to essentially lay out for you 10 key considerations and leave you with best practices, again, some also key strategies, as well as some of the key legal considerations that have evolved, particularly in the last near 2 years, given the complexities of our time. So that's what we've laid out to cover during this hour. By way of housekeeping, what I'm going to invite you to do is, as your questions occur to you, please populate them in the Q&A box. That's going to be designated for the purposes of us reviewing your questions and providing answers, which we're going to leave a little time at the end to do. What we typically do if we get a lot of questions on this subject, we'll give you some bonus time, but we'll officially end knowing that many of you may have other priorities or things that you need to tend to right after 90 minutes. Or so this is an hour. After the hour, we will end the session officially, but know that we generally go on for about 10 minutes, 15 minutes, depending on the number of questions you receive. If you're having technical difficulties, please feel free to use the chat. That chat box will be triaged by Eric Hurwitz, who is our legal operations administrator, and he's going to be ensuring that you don't have any issues that we can help you solve. So with that, let's dive in. Let's talk about workplace investigation challenges. And I want to start off very generally, as I promised to do, just exploring with you for a moment what typically makes investigations complex. So just generally, it could be the nature of the allegations, and we're going to talk about what we're seeing more frequently now as it relates to subtle allegations of subtle discrimination and discriminatory harassment. There are certain allegations that are coming forward right now that are just inherently more complex and challenging to deal with, but as well the scope. So the number of parties that are involved, the nature of the evidence, witnesses. Sometimes you're dealing with third parties, such as, you could be dealing with the police who are conducting a parallel concurrent investigation, and that can create all kinds of complexities. As well, the nature of the organization. In some organizations where it's very tight-knit, we're helping an organization right now conduct an internal process where a lot of the employees are very long service. They're a smaller organization. They want to conduct the investigation internally. They are governed by a board, but everyone, they consider themselves to be a tight-knit family. So it really makes it difficult for them to conduct the investigation internally, but also sometimes where organizations are, a lot larger. We deal with a lot of institutions, including in the school board context and education context generally, as well as municipalities, when there are all these different roles, like equity roles or human rights offices, as well as HR, that can also make the process complex. So there are a number of factors to take into account based on the nature of the organization, and the nature of the organization can lead to complexities when you're dealing with investigations. Legal requirements. The ground has rapidly shifted beneath our feet. We're in a very dynamic legal climate right now as the law is trying to catch up and recourse in the context of our current challenges and all of the impacts that workplaces have sustained, and just the shift that in employee expectations with respect to how they should be treated within the workplace context. So that the law has been shifting legal requirements, not only from a legislative perspective, but also decisions of human rights tribunal and courts, arbitrators. These are things that make workplace investigations very challenging because you have to stay up to date. Otherwise, you could be easily conducting a deficient process, which will have implications, which we're going to explore in a moment. Resolving credibility issues. Some investigations are, they said two contrasting version of events, maybe not a lot of existing corroborating evidence. This is where it is really, really important for investigators to have training to resolve these credibility issues or reliability of the evidence issues. And this is, I would say, from a technical perspective, one of the most complex requirements that investigators have to meet in the context of performing investigation or conducting investigation processes. So that is something that inherently makes investigations complex. Ongoing relationships within workplaces, investigations occur, parties either still need to work side by each, as I like to say, or even when there is a result where an employee may lose their employment, it still disrupts the team environment, the culture, and this is something that can make it very difficult post-process as well to kind of restore the workplace. So you have to bear in mind when you're conducting an investigation, the ongoing nature of the relationships. Bias, conflict of interest. This is something that investigators have to be vigilant for. Where there's bias or conflicts, that they will undermine the veracity of the ultimate findings and report or conclusions that are made as outputs of the investigation process. And so bias and conflict of interest in navigating these kind of mines that are on the minefield are really important. And again, it leads to complexities in investigations. Labor management relations, dealing with unions in the workplace and their expectations with respect to how an investigation process should be conducted. That's a very kind of delicate dynamic in many contexts, and it's something that does lead to complexity. And the final one I'll mention, but it certainly isn't, this hit list that I have here, it's not an exhaustive list, but for our purposes and time, the last one I'll share is internal capacity to conduct the investigation, right? So oftentimes when we're conducting investigations internally, if you don't have the capacity to take on the process, which some processes, depending on the complexity, again, scope or nature of the allegations, et cetera, they could be fairly long. So it's ensuring that you are continuing to move the process forward, as well as manage your other priorities. And when you're not able to do so, and you don't have the capacity to conduct the process, it can compromise the ultimate result of the process due to delay, evidence being spoiled or unreliable. So having capacity is something that leads to the complexities of conducting investigations internally. Here's some of the common pitfalls that investigators, organizations generally face when investigating. So this is where the wheels can pop off or there can be a derailment. A lot of these issues are preventable. They can be preempted, but just so that, and I'm sure some of them will resonate for those of you that conduct investigations. But first one, failing to prepare, right? Oftentimes, and I don't know why, because investigations are so complex, but investigators will start the process like a gun has gone off and they're sprinting from the blocks. Really, investigators need to take time to prepare, and where you don't, you are going to bump along the tarmac and you may never get to lift off because, again, investigation processes are constantly under scrutiny and they can be fatally derailed if they're not properly prepared for. Not following a process. Similarly, there should be a well mapped out, consistent process, and investigators sometimes, again, will try to wing it. They'll try to go with the flow and think that they can FIO it, figure it out. That is not how it works. You need to have a structured process. We're going to talk about this more in a moment. Not taking the complaint seriously when investigations are conducted, particularly where we may know parties, Brenda, she's always a complainer, she's bringing this forward. We'll just kind of move the shells around because we have to. Or, Dave is such a good guy, there's no way he would have intended to create any offense or to have, harmed this individual in this way. So, and again, this can all lead to, and is a result of our biases, but it can lead to us not taking the complaint or the process seriously. And, any escalated investigation that might land at the Human Rights Tribunal or before a court, decision makers are very increasingly scrutinizing processes to ensure that you're not just doing a surface process, that it truly is an inquiry where that you're fact finding and you're considering and assessing evidence and you're coming to findings and perhaps making determinations in a way that the processes should be conducted. So really inquiring into them impartially, objectively, and fairly. And that's a good segue to procedural fairness. There are procedural fairness requirements that if they are not met in an investigation process, it can fatally derail the findings, the outcome of the process, and you're not going to be able to rely on any conclusions made or decisions made that rely on findings that are flawed. And Alex in a moment is going to get into procedural fairness in greater depth, but this is one of the common derailments that organizations or investigators experience when they're conducting processes internally. They don't provide the procedural fairness to the parties that is required. Not conducting the investigation in a timely manner. We talked about that a moment ago with respect to ensuring that you have capacity. Not thoroughly assessing the evidence. So again, maybe cherry picking some details, not looking at it objectively and impartially and thoroughly, that can lead to, again, a flawed outcome. And again, an outcome and findings that you can't rely on. for the purposes of making decisions, and losing objectivity. So again, I've been repeating certain things, but they're worth repeating because when it comes to a common pitfall, sometimes, particularly in organizations where individuals wear multiple hats, and we oftentimes do. Think of an HR professional within an organization who may need to problem solve and resolve disputes or repair relationships, et cetera, by day. And now all of a sudden you have to assume an investigator hat, where you're required to be impartial, to just conduct an inquiry process, to not fix anything, right? And to, again, stay objective. Sometimes when we're not able to maintain that objectivity, that can harm or impair the outcome of an investigation process. So these are the general considerations, complexities, pitfalls that are inherent to workplace investigations. Now let's add the overlay of our current climate, the impacts from the pandemic, our mental health crisis that we're going through right now, and that I still say we're probably only seeing the tip of the iceberg in terms of the impacts that are going to impact the workplace, but not only the workplace, just society in general. Social justice movements and the focus on injustice, unfairness, inequity within the workplace. These all have led to a considerable spike in complaints being brought forward, concerns being brought forward, incidents within the workplace that require investigation. Harassment, discriminatory harassment, and just general conduct issues, they are on the rise, and there are legal requirements Alex is going to speak to in a moment, and compliance obligations that have to be adhered to that are important when it comes to resolving these issues. And in some cases, it's prescribed that you can only get to resolution by first conducting an impartial inquiry process, which is an investigation. So let's explore some of the current complexities that result from our current climate. The nature of the issues that are coming forward, as I mentioned earlier, are much more difficult to explore by way of investigation. As a result of the focus on, as I mentioned, social justice and resolving inequities and unfairness within the workplace that has been a result, a lot of employees feel very emboldened to bring issues forward. And the nature of the issues that are brought forward are, again, they're very difficult to triage and to escalate, particularly using our existing pre-pandemic policies. So, micro inequities, microaggressions, micro invalidations, subtle forms of discrimination. This is what is coming forward more regularly now within workplaces, and you really have to have a particular level of skill and ability and to be equipped to properly triage these types of escalations. Again, because employees are emboldened now to come forward, we're dealing with a lot of very historical issues, things that happened years ago. So, and how do you properly investigate something that's historical when the evidence that you need to rely on, it may not exist? So that's another thing that a lot of organizations are dealing with currently. Process deficiencies. Again, the policies, the processes that, before organizations had instituted to deal with complaints and escalations within the workplace, they're not holding up. They're not serving organizations and investigators to properly inquire into the concerns that are coming forward. Think about some of the policies that we have, and that's the next thing, our policy deficiencies. Some policies, they speak to only overt acts, for example, of misconduct. Let's think about discriminatory misconduct for a minute, where the inappropriate and unacceptable behaviors may relate to slurs, sending offensive and content via electronically to colleagues, etc. So real overt behaviors. They don't speak to the subtle types of misconduct that the Human Rights Tribunal, courts are really considering now in terms of those types of misconduct that oftentimes the perpetrator is like, well, I was actually just trying to pay a compliment, like saying, oh, Laura, you're so articulate, or telling somebody that is perhaps older, marveling at the fact that they can navigate technology. And oftentimes the challenging thing with not having these types of behaviors captured in policy is that they're overlooked. And what we often see in organizations is when the complaints come forward, those triaging will say, well, it's not in the policy, so what do you want us to do about it, right? And that's doubling down on the hurt, the unfairness, and the ill treatment that the complainant feels that they have endured within the workplace. So policies have to be updated, upgraded to really meet the types of complaints, the nature of complaints that are coming forward intensely in our current environment in the new workplace. Greater scrutiny of investigation policies and practices and processes. That is what organizations are facing now as a result of escalations to decision makers, third-party decision makers that are essentially saying, your process doesn't cut it for a number of reasons, the number of which we are going to cover in a moment. Also, complainants are very sophisticated now. Oftentimes, the complaints are being brought forward with the specific kind of terms of art being referenced. So I have been microaggressed by, I have been gaslighted, micro-invalidated by, and these are things that oftentimes, when investigations are conducted, particularly internally, can be very disconcerting for an employer or an investigator that may not have leveled up their knowledge with respect to what these terms mean and how to triage and deal with subtle forms of misconduct that are, again, what we're seeing more intensely being raised in our current climate. And there's also increased recognition of harm by third parties and increased liability and damages as a result. I mean, the Human Rights Tribunal has meted out damage awards. The highest, I believe, is $200,000 related to a harassment matter. And so the consequences are becoming much more serious and much more costly for organizations. And just quickly, with respect to, why should you care? Why does it matter? Why is it significant for us to focus on how to properly conduct an investigation? Because there are very significant and consequential impacts to not conducting a proper investigation process. So if you have inaccurate findings, then you're, first of all, not getting to the bottom, the root cause of whatever the concern or complaint involves, which is important. I say to organizations often when I'm conducting investigation training internally, or in the context of maybe a debrief after we've conducted a process as an external third-party investigator, I always say, listen, investigations aren't a bad thing. Investigations provide organizations with information. And we have to really, take this as an opportunity to focus on something that may need to be fixed, may need to be enhanced, a training need. You may need to, reintroduce, reinforce certain expectations, conduct expectations within the workplace. So inaccurate findings deprive the opportunity to identify and leverage whatever information in an investigation can help an employer glean. But also, if you have inaccurate findings, you're not going to be able to rely on them for the purposes of making decisions, right? So inaccurate findings, a flawed process can have significant impact. Also, legal exposures and escalations result when you don't have a process, an investigation process you can rely on. And when an outcome, a consequence, could be discipline, is meted out as the outcome of an investigation, the unhappy party that may not like the decision will, if they escalate, particularly through counsel, they're going to tire kick, and they're going to try to undermine the the process and the veracity of the report and the findings, because that will take the legs out of whatever decisions have been made as a result of the findings. So, this is where you see escalations to arbitration and kind of in unionized environments, litigation. And again, as I mentioned before, damages awards have gone up considerably. And where you have an employer that's on the wrong side or the downside of a decision, it impacts their credibility, and also it can create lost trust and engagement within the workplace, and there can be reputational fallout, not only for the employer, but if you have a flawed investigation, it can also create unnecessary reputational impact for those that are involved if you don't come to the right outcome, okay? So with that, and knowing that we only have an hour, so I'm skidding through this fairly quickly, but I do want to turn you over to Alex, that's going to walk you through the hotspots. And the hotspots are the key considerations, and we have 10 that we want you to have on your radar as you turn to reviewing your investigation processes, your policies, and you try to kind of level up for the times that we're in. And just to give you a little bit of context around these 10 considerations, our firm has been brought in to, in the educational context, municipalities, to certain corporations, as a proactive exercise to conduct organizational reviews. So what we're sharing with you is very high level, what we call our gold standard. So when we're assessing systems, processes, policies, and practices as they relate to triaging of complaints and investigations, these are the kind of the 10 key core factors that we assess against to give the organization a sense of where they might need to level up or what they may be doing well. But I'm going to turn you over to Alex to walk you through these 10 key considerations or hotspots. Alex, over to you.
Thanks so much, Laura. So as Laura mentioned, we do have 10 of these. There is some overlap between the different slides, and I'm sorry, my slides have decided that they are in a hurry. I'm going to flip us back one. But we're going to be starting off with compliance. And so again, as we go through, you'll see that a couple of these items, there's a little bit of overlap. There are considerations. To focus on compliance, as much as we can carve it out from the others, this is really referring to acting in accordance with applicable legal and policy requirements. So when we're assessing, what we're looking for in terms of the gold standard that Laura mentioned is that systems, processes, and procedures adhere to the legal requirements that regulate practices in the applicable jurisdiction where the employer operates, and workplace practices are consistently in line with the policies and applicable legislation. So the requirements, it may come from statute, they may come from regulations that have been filed under various legislation, they can come from case law, and in some circumstances, governments have provided guidelines and additional assistive documents. So for example, in Ontario, there's a code of practice, which is not technically a legally binding document, but it does give you a hit list of what the ministry will look at if it comes to the ministry's attention that there may be an issue with an investigation process under the Occupational Health and Safety Act. And following the guidelines isn't a guarantee that your investigation will be appropriate, but if you don't, there's a good chance that there will be issues that'll lead to the kinds of impacts and consequences that Laura has already set out. So just to give you an idea, for example, of what's included in a document like the Code of Practice in Ontario, the Code of Practice states that an investigation has to be objective and has to be concluded in a timely manner. It actually says 90 calendar days or less, unless there are extenuating circumstances. And those could be things like more than 5 witnesses in an investigation process, or something like a key witness being unavailable due to an illness or a lengthy leave. And so the Code of Practice, for example, sets out 7 steps that an investigator has to comply with to make sure an investigation is appropriate in the circumstances. And these include ensuring the investigation is kept confidential to the extent possible, that the investigator thoroughly interviews both the complainant and the respondent or respondents, that the alleged harasser is given an opportunity to respond, which is very closely tied to procedural fairness, which Laura mentioned, which we'll dive into specifically in a little bit. The investigator also has to interview any relevant witnesses. review any relevant documents, take appropriate notes and statements during the interviews, and ultimately prepare a written report that concludes certain items. And where there is a guiding document like this, there's more detail to all of these, but I'm just sort of going through it high level to give you an idea of the kinds of requirements that may be included in addition to the broad strokes set out in the legislation. And we have now many decisions from various adjudicative bodies that have told us, where organizations have gone wrong and what happens when they do. So I'll give you one example, which is an HRTO, a Human Rights Tribunal of Ontario decision from last year. It's called AB and Cooksville Hyundai. And we will be providing links to the cases later on as well. But in this particular situation, there were allegations of sexual assault. There was an event at which the complainant, who was a parts driver, attended with the personal respondent, who was her boss, the parts manager. And she woke up next to him and found that he was actually touching himself in a sexual manner with her hand. There are a lot of interesting and complicated investigation issues in this case. I won't go through all of them, but what I would want to draw your attention to is that in this specific case, the investigator was the company's external human resources resource. And the investigator met with the complainant, started off by asking the complainant if she would accept an apology. The complainant had asked for a change in reporting structure so she wouldn't have to see her manager at work, but HR, the investigator, only raised the possibility of using the employee assistance plan, didn't really address that. And the day after the interview, asked the complainant to put the complaint in writing. Meanwhile, met with the respondent before the complaint was provided, and essentially asked whether there was anything non-consensual that had occurred. The allegations in their entirety weren't specifically put to the respondent, and he didn't raise the incident that the complainant had talked about, and so the investigator didn't ask about it. The complainant sent in her written complaint a couple of days later on April 8th, and 30 minutes after the written complaint was sent, the investigator said the investigation is over and no report was prepared. None of the witnesses who were mentioned were spoken to, and the policy wasn't referred to. And what also happened in this case is the complainant asked, how was the decision reached? What happened? And the investigator ended up sending an email that said, as you recall, we investigated the allegation you made. The investigation concluded that while both of you agreed, you were both drunk and slept in the same bed, you were the only one who recalled the particular event in question, and the respondent denied it took place. And the investigator said, recognizing this is a classic he said, she said situation, we made sure you didn't report to the respondent any longer. The complainant took issue with this characterization as a classic any sort of situation. And ultimately, the HRTO looked at this investigation and said the investigator couldn't have come to findings because the investigator conducted an insufficient investigation. In fact, they called it seriously flawed and insensitive, both with respect to how an investigation is conducted and also the email response that was ultimately provided to the complainant, which the HRTO actually called egregious and false in terms of its content. So this case is just an example to underscore that where you have investigations, you have to make sure they're compliant with legal requirements. You also have to make sure that they're compliant with whatever policy is in place. And the ultimate findings of the investigation have to be clear. The key thing to keep in mind here is that, as Laura mentioned, a lot has happened. Investigations were always complex. They are more complex now. They are likely to keep getting more complex, and the law is evolving rapidly to make sure that all of these relevant circumstances are addressed, which means that employers need to make sure they're reviewing and revising processes and policies related to investigations. And you also may need to ensure that your processes and policies are regularly reviewed, certainly if they haven't been, but even if it's been a while since the last time they were revised, employers will be well advised to conduct a legal review to make sure that all of the sorts of technical requirements and the developments that we've seen in legislation and case law are addressed. The next hotspot that I want to discuss with you is process clarity. And process clarity really refers to the extent to which the structure of the process is clear and employees are certain about how to perform their roles. My apologies for the slides jumping around back and forth. It appears that technology is not my friend today. For investigations conducted in-house, there are a lot of different ways in which the structure may work. And as Laura mentioned, we're frequently engaged to go into organizations, assess how complaints are made, how they're triaged, how they're investigated. And so we've seen firsthand that there are a number of ways to do these things. Some organizations have everything go through human resources. Some might have an equity office or a human rights office that's external to human resources. Some may have other offices that they've created specifically for investigations. And the existence of all of these different venues can sometimes cause confusion about how complaints are made, how they should be triaged, and how they should be investigated. So when we're looking at the gold standard of what we would like to see in terms of process clarity for an employer to make sure that everything is done as required, all participants in the process should be certain about how to perform their role and how it fits into the overall process. And this requires the process to be very clear. Sometimes there are a lot of different people involved in these processes. There are employees who are making complaints, there are internal investigators, there are decision makers, and some of these people may have multiple hats at any different point in the process. You know, in certain circumstances, HR may be involved in decision making. In other circumstances, an HR professional may be conducting an investigation. What's really key here to keep in mind is that given all of the changes that have taken place, a lot of organizations have been really reactive because of how issues have evolved. And this can create quite a lot of confusion. As a result, it's really important to make sure that if you haven't recently, review your process, make sure that the process is really thought out, clear, and consider whether it may need to be reworked once the ground has settled a little bit to address any things that may have been put into place on a reactive, somewhat quick and maybe not entirely thought out basis. The next hotspot is conflict mitigation, and this refers to addressing real and perceived conflicts of interest. Again, it's really key that real and perceived conflicts that could harm the integrity of the process are considered, identified, and addressed. And I'll give you another case law example here very briefly. This is a 2020 BC Supreme Court decision called Hernkeu and Central City Brewers and Distillers. And this was a wrongful dismissal situation in which the CFO was fired for cause due to issues around bonuses he took for himself and a vacation he took. And even on the employer's account, the CFO had been a loyal and competent employee for years, but ultimately, virtually overnight, he was locked out of the office and his employment was terminated without notice. And in this case, again, I won't go through all the details, but what's key for the purposes of conflict mitigation is that the owner of the company was the one who investigated, but he had a very skewed view from the outset, and that resulted in a highly inadequate investigation. He was angry, he was confrontational, he didn't make any genuine effort to review the full circumstances, he didn't consider the possibility that the plaintiff had made a mistake, he also didn't consider the possibility that he had made a mistake and forgotten conversations with the CFO where he had approved certain things. As a result, in this case, there was a question of whether the investigation breached the duty of good faith. And it's not the case that every insufficient investigation may result in damages, but in this case, the investigation was so unduly insensitive that it was found there had to be an award to recognize the person was treated very unfairly. In this case, that resulted in an award of $35,000 in aggravated damages for the mental distress caused by the unfounded allegations and the failure of the employer to conduct a proper investigation. And this was in addition to the significant termination notice entitlement that the employee received. Again, what this case represents and what this particular hotspot focuses on is making sure that we're vigilant of biases, because we all have biases to one extent or another, and that's human. But recognizing the existence of them and assessing them from the outset is really key, both for actual biases and perceptions of bias, because sometimes the idea that in a workplace somebody may be perceived to be close friends with somebody else, or an investigator may be confused with a decision maker. Those sorts of things can really harm a process, whether there is true bias or simply a perception that there might be bias. And so in addition to being vigilant and assessing them, a good tactic where you can is to investigate in teams and have an investigator and a designated note taker who's really involved in the investigation process, who are discussing issues related to the evidence, talking things through, and can check each other's biases. In addition to having really solid policies in place, the next hotspot I want to touch on is communicating them. And so it's really key here to ensure that everyone in the workplace is actually advised of conduct and process expectations. We've seen in our experience that there are some situations in which organizations have excellent processes on paper, but nobody is aware of what they are. And so it's really key that all policies and key elements of the process are socialized throughout the workplace, and that training is provided and refresher training is provided regularly so that everybody knows, because your process may be perfect, it may be perfectly clear, but if it's not communicated, this is a problem because failure to set and manage expectations can create mistrust that can significantly undermine processes related to workplace investigations. So your policies have to be clear, but the communication also must be clear and there must be consistent training. Moving on, the next hotspot I want to focus on is procedural fairness. And this is one that's a little bit more technical than some of the others. But as Laura mentioned, this is a very common spot of derailment for investigation processes. And essentially what workplace investigation procedural fairness refers to is that parties have to have a full and fair chance to participate in the process and present their evidence. And this refers to both the complainant and the respondent. So in terms of what this ideally looks like in a process, it would be the processes are conducted in a fair and impartial manner, that all parties have a full and fair opportunity to be heard, and decisions are rendered without real and perceived bias, which we just talked about, based on evidence that's actually collected, and investigation outcomes aren't prejudged and everybody is treated equally. Often in practice, there's a lot of emphasis on procedural fairness when it comes to the respondent, making sure they have a full and fair opportunity to respond to specific allegations, and that's really key. But procedural fairness with respect to the complainant is also important, and making sure that, if certain contradictions arise in the interview with the respondent, that the complainant is circled back to and given the opportunity to reconcile these contradictions so the investigator isn't left in the position where they're making assumptions and potentially not making evidence-based decisions. What's really key here is, again, not to prejudge, make sure that you consider evidence, but also consider sometimes that not even entirely clear evidence that we assume is very clear, consider the possibility that it can be inaccurate. And a quick example that I want to refer to here is a 2020 arbitration decision between CHEO and the Ontario Federation of Healthcare Workers, in which there was a grievance related to inappropriate messages that a male griever had allegedly sent a female work colleague through Facebook. There was no dispute that these were offensive and sexually explicit. There was no dispute that they would be a serious violation of the hospital's policies. And ultimately, actually, what happened in this case is by the time this decision happened, the hospital had acknowledged that the respondent had done nothing wrong. He was actually the victim of somebody else who had framed him. But what the arbitrator looked at in this case when assessing the investigation was that the hospital didn't rush to judgment in deciding that the griever was the one who made the offending messages. They investigated. They considered that the messages could have been fabricated by the complainant or somebody else, and they didn't come to a final decision for a period of about 8 weeks. But ultimately, management didn't have a copy of the offensive message at the time of the meeting and didn't get the exonerating evidence until the arbitration. So to a certain extent, the confusion was reasonable. But what management could have done in this case, and the only substantial flaw, was that they failed to provide the griever with the opportunity to see the actual messages. If he had seen them, he would have been able to point out, for example, that the writing style in the messages wasn't his, that he was on a call with one of his family members at the time when they were sent, and in this particular case, that the penis pictured was not in fact his. And so in this case, really the issue was that, the arbitrator wasn't convinced that this would have changed the outcome of the hospital's decision. And so the hospital's failure wasn't so unfair that it attracted damages, but it's really key to make sure that, if things come up later on in the process, you are circling back and you are providing a really substantive opportunity to reply to all of the allegations. Really, a lot of the takeaway here is that a lot of the procedural fairness issues that arise can be preempted through policies and solid processes. So again, circling back to the previous foundational hotspots that we covered, making sure your processes are solid and communicated will help address a lot of these procedural fairness issues before they arise. Accountability is the next item that I'm just going to touch on quickly, and this refers to clearly identifying who's responsible for different aspects of the process and holding them to account. So process ownership and responsibility for outcomes have to be clear. Expectations have to be clear, which we already discussed. And participants in the process have to be held accountable, and leaders have to encourage others to hold them accountable for any issues with the process. Accountability is the only way to ensure consistency in the process, which is another hotspot we'll address in a moment. And to ensure that people can be held accountable for whatever their role is in the process, employers have to make sure that they're properly equipped. So every role in the process should be trained in accordance with what's expected of them in the process and why that matters. So investigators need to be trained in terms of what it is that they need to do. Managers who may intake complaints need to be trained in accordance with what they're supposed to do. And employees need to be trained on what the process is and what's required of them in terms of reporting and participating in processes. Competence is our next hotspot, and this refers to having sufficient knowledge, judgment, and skill to perform the required tasks. This has been increasingly key, as Laura mentioned, with all the complexities that we've been facing. And so investigators have increasingly had to be up to date on legal requirements to ensure procedural fairness. These include things like making sure that when circumstances require it, your investigators know how to approach investigations with an anti-oppressive approach. So a framework or perspective that acknowledges social justice, addresses power differentials, and recognizes structures of oppression and barriers. And that they're aware of how to investigate with a trauma-aware or trauma-informed lens that acknowledges the role of trauma and focuses on what's happened to the person and what continues to happen to the person, instead of why they're responding in a particular way or what might be considered to be wrong with them. Another area where training and upskilling is increasingly required is credibility assessments. So sometimes you have a situation in which you have to decide which story might be more truthful, might be more reliable, and that credibility and reliability assessments can be very complicated. They arise when you may have a she said, or a he said, she said, or a he said situation where you just have two sides of the story and not very many witnesses. And so to give a very quick example here, there's a 2019 divisional court case called Joe Singer Shoes and AB. And in this case, the applicant had a number of vulnerabilities, and she ended up suffering very significant abuse by her employer that it started from sexual harassment and moved into sexual assault. She'd also had a workplace accident that resulted in a concussion and brain injury, making her evidence not very reliable. So the respondent's lawyer tried to argue that this case should just be assessed based on reliability. And the divisional court said, that's not right. It's much more complicated than that. You have to look at the totality of the evidence. And there was no evidence or findings that she couldn't perceive certain events, just that she couldn't recall certain things. And what she did remember, there were significant hallmarks of credibility because she remembered key details. And there was enough in this case for the tribunal initially and then the court on review to find that the evidence was credible and actually award the largest award that's ever been awarded in a human rights tribunal case, which was $200,000 for the sorts of treatment that she'd suffered. The key takeaway here, again, is to make sure that investigators are trained and make sure that they understand that we're in a very dynamic time. There's a lot of stuff that's going on. There's a lot of upskilling required. And by making sure they understand all of the sorts of moving parts and what may be required of them, investigators can also help the employer by identifying when they might be out of their depth, when they might not be prepared to conduct an investigation because of the kinds of issues involved. Moving on to our next hotspot, which is capacity. This refers to the maximum amount of work that can reasonably be performed in a given time. And the key issue here is to make sure the workplace has access to sufficient resources to assess and investigate all complaints in a timely manner. Sometimes you may have skilled investigators internally. We've seen this, but you might not have capacity to do the investigation, even if there's competence, because you just have too much on the go. And this is where upfront planning, as Laura mentioned, the preparation is really, really key. If you tumble into a process and find it's more complex than you expected, that's a problem. So it's important to scope it out, see how long you think it's going to take, consider what else you have on the go, and then consider that maybe, even if you have internal resources, it might be appropriate to have the investigation done externally just because you don't have the time to do it. And the last hotspot that I'm going to touch on is consistency. And this refers to making sure that all processes are done in a predictable way that conforms with workplace policies and procedures that hopefully you will have addressed when you focused on the other hotspots. All complaints have to be addressed and investigated in accordance with the same standards and guidelines. But again, not every process is going to be the same. Actual processes need to vary as necessary depending on what's appropriate in the circumstances. Again, you may need specialized training for the investigator. Some processes may be very short and simple, some may be very long and complicated. And here again, it's really important to make your plan, make sure you're referring to your policies, processes, and procedures, and that you don't fall into the trap of thinking, oh, well, I've done this before, this is going to be easy, I can just go ahead. You really need to scope everything out to make sure that there are no issues that arise unexpectedly that'll make the process inconsistent and undermine some of the good work you've done earlier on. And with that, I'm going to turn it back over to Laura for the last of our hotspots.
Thank you so much, Alex. And the last one I wanted to speak to because it is one of my soapbox issues, and that relates to restoration. To sum it up, when you're conducting an investigation process, you have to begin with the end in mind. And that means thinking about what post-investigation restoration activities should be considered and implemented. And you don't look at this at the end when the process is over. Restoration and knowing that workplace investigations can be such a destabilizer to culture, to relationships, to productivity, that you have to always think about, okay, what are the activities that we need to engage in, such as maybe recommunicating the policies and retraining on the policies, re-socializing, behavioral conduct standards. There could be restorative activities such as sensitivity training, sometimes on a one-on-one basis, sometimes across the organization. There are a variety and myriad of activities that an organization can engage in and should engage in to make sure that the workplace is restored and that it does resume productive functioning. And when it comes to restoration, last thing I'll say in the moments we have left before we turn it over to some questions is that you can preempt a lot of the fallout that naturally will occur as a result of an investigation process and the impact that it has on the workplace environment through your policies. So there's certain things that can be socialized and that you should update and upgrade your policies to include, such as, when somebody is, a respondent in an investigation process, if they are placed on a investigative suspension pending the outcome of the investigation, that's not a determination of guilt, right? Or of the finding of fault. These are some key themes. There are a number of key themes. I don't have time to share all of them with you because of the time that we have, but there's some key things that you can build into your policies to also help you restore and to preempt, again, some of the blowback, fallout, destabilization that will occur as a result of an investigation. So just moving through and just to round out a couple of things that I want to put on your radar before we get to some questions that we've received through the Q&A, and keep them coming, because again, we're prepared to stay on for a few minutes after, should we get a number of more questions. But we have a special edition of our In the Know newsletter, sorry. This one's on workplace investigations. It can be downloaded from the williamshrlaw.com website, and it has 26 pages. It is chock full of great content that speaks to the current complexities as it relates to investigations, provides guidance and considerations, and really can help you navigate this tricky terrain. So that is one thing that I definitely would urge you, if you already don't have a copy, to download. It's available now, and you can certainly access it easily through our website. As well, I want to put on your radar two exciting programs that I'm going to be delivering coming in the new year. They're all on the theme of leading in the new workplace. Leading in the new workplace, well, it really is a call to leaders, to HR, to level up their leadership to the new climate that we're in, all the complexities that we're facing as leaders, as entrepreneurs, as HR. And what we've done over the past, it's actually been over a year and a half, is work, that's Williams HR Consulting, that side, we've come up with a methodology, some really critical considerations based on foundational conditions that organizations must ensure are properly calibrated for the workplace to thrive and for employees to perform at their best. We're in the Great Resignation now. Being able to retain talent, attract talent is a huge issue for employers. And what we're going to be covering in this three-part webinar series is how do you ensure the direction of the organization is clear, that you've got the right psychological atmosphere for employees to thrive, and also how to optimize your people. And we're going to train our lens again on some very key components, key foundational conditions that will help you as, again, we restabilize, as we recourse, and as we improve and innovate coming out of the pandemic. As well, there's another series I want to put on your radar that's going to start in March, and registration opens in January, and that's on equity, diversity, and inclusion. For those of you that have attended sessions that I've done for the HRPA or and associations, there is a need for leaders, for organizations to really understand how to properly set strategy and intention around being equitable, being diverse, and being inclusive in the workplace. And what I've also seen in dealing with hundreds of organizations, including through the pandemic reality that we've been in, is that there's this conflation of these terms. So 3 separate webinars: equity, period, is the first one; diversity, period, the second one; inclusion, period, is the third. So if you're interested in attending these sessions, know that the first 3 webinars, which start in January on leading in the new workplace, you can, through the Williams HR Law website, we have a banner there, you can access registration. And again, for the EDI ones, they will be available for registration purposes in January. So with that, I want to turn to some of the questions that we've received. We are just at time. Some of these questions I can do really, really quickly, and then we will stay on. If you do need to leave, please, again, feel free to stay connected with us should you wish to follow up and you have some burning questions that you weren't able to have asked and answered during this session. We thank you for taking the time to join us. For those of you that took the full ride through the Hotspots series, thank you for joining us, and thank you for taking the time out today to focus on workplace investigations. Wishing you all the best for the holiday season, and looking forward to when our paths will cross again. But as for now, we're going to just turn to the questions that we have received. One, we can answer in fairly short strokes. This one is, can a supervisor put in a complaint about someone who reports to her in regards to microaggressions or slander? There's no bar on anyone bringing a complaint within a workplace, even if you are the leader and you have a complaint against direct reports. That is something that certainly pursuant to how our kind of legislative landscape and just the kind of legal landscape generally is exists, you certainly can bring a complaint against someone that reports to you. Now, there are perhaps some underlying issues with respect to, behaviors that perhaps should be subject to discipline that might not be handled effectively. So there are different complexities that exist when a supervisor is bringing a complaint against a direct report, but there is absolutely nothing barring someone in a supervisory role from bringing a complaint against someone that reports to them. Alex, I'm going to give this one to you. Could you please speak to how much detail must be included in a summary of investigation letter that's given to a claimant and respondent after the investigation is concluded?
Thank you, Laura. I would be happy to speak to that in a very, very general way, because this is one of those traditional lawyer answers that I'm sorry for, but it depends. Because it's going to vary depending on the type of investigation, what necessarily you have to tell them. You have to communicate the findings, because in most jurisdictions you're required to do so. For example, in Ontario, it's very clear. The Occupational Health and Safety Act, if you have a harassment investigation, you have to tell them what you found in terms of whether or not harassment has occurred. The amount of detail about the specific allegations really is going to depend on the situation. And since we can't give legal advice, if you have a specific investigation in mind, you get advice from whoever might be assisting you through that. But the other thing that always has to be in the letter is the corrective action that has occurred if there is action. So if you have allegations of harassment, they've been substantiated, and as a result, there's been a warning letter provided, or the respondent is no longer with the organization. Those sorts of things have to be communicated in the letter. And you don't have to say every single thing. In fact, there's a danger to oversharing in the investigation letter, because that might lead to potentially waiving privilege over your investigation report if you're trying to keep that privileged. So there is a balance to be struck, but those are the key items that need to be addressed. And then beyond that, it's on a case-by-case basis.
Okay, and there's a follow-up question from someone else on this front, Alex, that I'm going to lob to you. Is a written letter required by legislation, or is it just best practice?
So that depends, again, on the type of investigation and your jurisdiction. So again, to stick with our example for harassment investigations in Ontario and in a lot of other jurisdictions, you are required to provide a letter in writing. In other circumstances, you might not be, because there are some types of investigations you're not legally by statute required to undertake, but it's always best practice to close out the investigation in writing, because you want to have that record. It also gives you a snapshot to communicate it. It means that it's less likely that the outcome is somehow going to be twisted or misconstrued, and it is part of the process of documenting, because even where you're not required to, it's really best practice to document every step of the investigation, including what you found and what corrective action, if any, resulted, because that's, again, that's how you do your due diligence. That's how you protect yourself if there's a claim that some part of the investigation wasn't appropriate, including the steps that you take after as a result of what you found in the investigation.
Thank you, Alex. I'm going to keep you on the hot seat. I'm loving this. I may jump in though, because I can't help myself. Here's another one. How much protection should be built into policy to protect an employer who has employees working from home and only attending the office as need be? Will employment terms be inferred in this case when the employer wants everyone to get back into the office, either full-time or on a consistent hybrid basis?
Oh, that's a very interesting question. So in terms of protections related to workplace investigation, if I'm getting the point of the question accurately, and please let us know if I've misconstrued your question, but the fact that the employee might be working somewhere else isn't going to eliminate the employer's responsibilities in terms of what needs to be addressed in terms of harassment or discrimination or any related item that you may need to investigate, either because there's misconduct and you're building up to a just cause termination, or there's fraud, anything like that. So in terms of protections related to the policy, if you have a very strong policy already, a lot of it is going to be transferable. But some of the things that are important when you may want people to be coming back, or you may be worried about conduct that's occurring remotely, is making sure you have specific examples of misconduct in the policies that refer to things that might happen virtually. You also want to make it clear that if somebody is remote, or if, for example, you place somebody on a suspension pending the outcome of an investigation, you reserve the right to communicate with them and have them either perform work during that time or come into the office if necessary for the investigation. So again, these are some of the things that you can plan and preempt. And underlying occupational health and safety, and many of you will have heard us talk about this before, there's what's called an internal responsibility system. And so we always recommend that policies touch on this IRS, which in occupational health and safety legislation really across the country refers to the fact that health and safety is really a joint responsibility. So one of the biggest protections you can include in your policies is to make it clear that it's not all on the employer. Employees have an obligation to participate in the investigation process. They have an obligation to bring concerns forward when they learn of them, just like you have the obligation to investigate complaints and incidents. So that's a key protection that I would say should be built into something like that.
And thank you, Alex, for focusing that answer on the investigation context. But I'm going to pull the lens back and answer this a little bit more broadly. We have had a very, very seismic shift to and significant impacts on the workplace, which has changed everything, how we provide service and products to our customers, but also to our culture and also to the expectations held by employees and to workplace rules as well. And what's happened during this time of near 2 years is there have been things that just out of necessity we've had to morph, modify, or just change just to ensure that we stay productive. And, what I would say just very globally to this question is, you don't want to leave anything to chance or default. You want to make sure that you upgrade, update your policies to reflect the expectations that you have for employees, the requirements that they also have, any change in entitlements, because there have been shifts and changes in entitlements across the board, and also that reflect your obligations and assurances that you are going to create a safe workplace, not only from a physical perspective, but also from a psychological perspective. So that's what I would say to that. I mean, just adding to it, it's a great question, but again, there's a specific response as it relates to investigation, but just generally speaking, you need to make sure that you don't leave anything to chance. We're in a very dynamic environment right now, and you want to, very strategically and intentionally set the expectations for your workplace. There's a question here. What is the gold standard required around separating individuals in a reporting relationship during an investigation while balancing the reputation of the respondent? That is very tricky terrain. I'll take that one on directly. I mean, ultimately, when you're considering separating parties or perhaps putting a party on an investigative suspension, irrespective of whether or not there is kind of this high level appreciation that it's not punitive, people tend to prejudge, and it can be reputation impairing for the party that is either stood down by way of a suspension or if there's a separation. So you want to make sure that you very, very carefully conduct a risk assessment. And generally, when you're dealing with discriminatory harassment or harassment in general, you've got to bear in mind that the obligations almost across the country as it relates to harassment reside in health and safety legislation. So you should be approaching this from the perspective of assessing the risk. What's the risk of the parties working together, continue to work together? What is the risk of what risks exist that would require or would warrant placing someone on an investigative suspension, right? But, it should be, again, please socialize in your policies. Best way of doing this, that, when there's an investigation, it may not be, constructive to have the parties work together and during the investigation process. And it's very difficult for someone that is a direct report to bring a complaint against someone that they report to, and to require them to continue to work together, right? So, you can speak to the practical realities in your policies preemptively of, needing to separate, needing to stand down by way of suspension. But if you are going to place someone on suspension, there are specific considerations that need to be taken into account, including the risk that you're addressing in needing this person to not be working, at least or approximate to the complainant during the investigation process. All right, there are a couple more that I don't want to leave questions unanswered. So let me just handle a few more. Maybe I'll lob this one to you, Alex. This is, let me just see. I think we've gone through most of them. Here's one. In trying to be fair, how do you manage an investigation when it seems staff is colluding against a manager?
That's also a very interesting question. That's related to one of the things that we talked about, where training is really important and competence is really important, because that's where you get into your credibility and reliability assessments. So credibility and reliability are very, very complex. And what you're looking at is a number of characteristics that essentially boil down to, when there are differing stories, who do you think is more honest and forthright? And to what extent might there be support for one version of events or the other? And the questioner is absolutely right to say, sometimes stories are very much in line, and that seems a little bit suspicious. So you take that into account. You consider the relationships of the parties. If the witnesses are all really close to one of the parties, say they're all, good friends with the complainant and they've had acrimonious relationships with the respondent, that's not necessarily determinative, but it's definitely something that you consider. If the stories look a little bit too aligned, if you're, getting the exact same events in the exact same words, sometimes that happens. And part of it is experience. And again, training, making sure that you can separate and assess out. Memory is difficult. And people generally aren't going to remember the exact same thing in the exact same way. So sometimes when they do, that could mean that it's rehearsed. It could mean that it was just something very impactful. So I know I'm not necessarily providing you with a helpful definitive answer, but what I would boil it down to is the training and the experience, making sure you're considering all aspects of the credibility and reliability assessment. And part of it is going to be, circling back to the other party and giving them an opportunity to say, you told me X, I've heard Y, can you explain? In some circumstances, that's also appropriate, because again, you're not prejudging, you're not making assumptions, you're not making any determinations until you've spoken with everybody and you've looked at all the relevant documents and evidence, and you're looking at that holistically. So you also ask for the paper trail. Are there emails? Is there something there that maybe contradicts what even a group of people is saying? And then you weigh that as well.
Thank you, Alex. And just in keeping with the kind of 15 minutes over that we're prepared to do, I'm going to take a final question, which is, can you review what you mentioned about having a legal review done for an organization? And I guess the legal review, just in terms of kind of conceptually, is different and distinct from an investigation in that you really don't have, when you're conducting a review, be it a climate review or a systems and processes review, you're not dealing with allegations against an individual. So you don't have people on the hot seat being respondents. You're inquiring into and reviewing and assessing the standard to which, in an investigation context, the investigation process is being conducted or not conducted. And that's why what we have done is we've created our gold standard against which we evaluate, assess, and then assess gaps, provide feedback, and we provide an assessment and recommendations to organizations on how to remedy their deficient practices, policies, and processes as it relates to the complaints escalation, triaging and in terms of conducting the investigation and all of the post-process activities, because we do focus on restoration as well. And the reason why this type of review has been very in demand these days is because there have been an increasing number of investigations that are required to be conducted, and it's costly to have them done, all of them done externally. When they're very complex, yes, you bring in a third party. When you require even the optic of objectivity, you bring in a third party, but all of them, because not all investigations are these big kind of Sherlock Holmes inquiries, they can be done internally, but you want to make sure that they're done properly and that your systems and processes will yield the outcomes, the findings that can be relied upon. Because if they don't, and you don't have the proper kind of infrastructure, then you're going to be left with not only a deficient outcome and exposures to liability and perhaps damages, but also there's going to be mistrust, internal mistrust, and lost credibility in the employer in terms of how they go about such a critical activity that is required in organizations, being workplace investigations. So thank you for your questions. Thank you for those of you that hung out with us in OT overtime. And again, wishing you all the best of everything as we go into the holidays and as we move hopefully into 2022. Let's make it a great year.